Starting live streaming right now. 3, 2, 1. Over to you, Vijay.
Good evening, everybody, and welcome to another edition of the ICCC Thursday Talks. Today's topic is COVID-19 and legal contracts. And to speak about this subject, we have a brilliant panel of eminent lawyers. We have Mark Persaud, Senior Counsel at Persaud Law Firm, Sanjeev Mitra, Partner at Aid and Berlis, Daniel Schwartz, Partner at Thornton, Grout, Finnigan. And as moderators, we have Pramod Goyal, President of ICCC, who will be running a section called Hard Talks with Pramod Goyal. And yours truly, Vijay Thomas, I'm the Vice President of ICCC, will be moderating the session. So welcome everybody, and those of you who are joining in via Facebook Live, we are open to questions. So please, in the comment section, write in your questions, and we will get them answered by our eminent panel. So what are we going to be speaking about today? So the topic that we're going to be speaking about, legal contracts, is specifically what the topic, the aspects of legal contracts that we'll be talking about today are what contracts are going to be impacted by COVID-19, legal obligations of small business unable to implement contracts, parties, remedies, a best business solution to address any potential non-performance, what legal rights and remedies do businesses have while working with third parties and mitigating impacts, and how can small business ensure that they are compensated if obligations are unmet by their contractual partners. Also, what is force majeure and how does the force majeure clause work? And how can small businesses claim that a contract is frustrated? And which counterparties are likely to be impacted by COVID-19? There's a whole lot of stuff here. So we'll try to keep our panelists on the ball and on time. And we will, without further ado, move on. As we move on, I'd like to mention the what ICCC started off a couple of weeks back, the ICCC Small Business Assist Program. Now, this is something that we started off when COVID-19 hit. We've realized at ICCC we've got a bunch of customers, a bunch of our members that are small businesses, and we have a large number of professionals as well. IT professionals, accounting professionals, lawyers. So we've decided we can bring these two parties together. So we have a phone-in counseling free session of 30 minutes. So all you need to do if you're a small business and require some assistance, require a sounding board, you want to talk to somebody, send an email to icccc@icconline.org, and on the subject say Small Business Assist Program, and we will connect you to one of our volunteers, volunteer experts, and they will help you with some of the problems that you might be facing. So next on our agenda is the names of our presenters, and as we said, we'll have each of our presenters go, and then we'll have the session that we call Hard Talk with Pramod Goyal and a Q&A with the audience at the end. So we need to have all those questions coming in. So we have a disclaimer. We have a lot of lawyers on the panel. So, we had this disclaimer even without the lawyers, but I'll go through this quickly. The information provided by ICCC at this webinar does not constitute legal, tax, or accounting advice, but is designed to provide general information relating to business and industry. The views expressed by the panel members are their own personal opinion and do not necessarily reflect the official position or policy of ICCC. So coming to our first speaker, Mark is a senior legal counsel at Persaud Law Group Professional Corporation, and he's going to be speaking about force majeure and some of the points around that. So over to you, Mark.
Thank you very much, Vijay. Welcome to everyone. Thank you for being part of this webinar. Um, to thank the President and the ICC and all its members and Vijay and the panelists for being here and for you joining in. We're facing unprecedented issues in these unprecedented times. And we must remember that this pandemic is a relatively new phenomenon in terms of how we are able to respond contractually and otherwise to the many issues that have arisen. The courts are still grappling with a lot of these issues. As lawyers, we have a sense of where they will go. However, the ultimate arbiter will be the courts, and we will look towards them for direction. As I said, they are still trying to figure out things. And so a lot of things now are not cast in stone, but we'll have to see it as a work in progress, which will evolve over time. I will briefly speak to you about two aspects of contractual relationships that are going to be quite common in the coming months and even years. One of the pressing issues people will have to embrace is I cannot fulfill my contractual obligations. What do I do? I simply cannot do it. I cannot proceed with this contract. How can I get out of it? What are the possibilities? Well, two issues will emerge, or two legal principles that you will be invited to look at. And if you're having difficulty with your contractual legal obligations. First of all, the most important thing is to start reviewing your contract to see what are the contractual terms and whether any of these principles will apply to you or if there's any leeway in terms of it. Always go back to the contract to see what the contract says. So pull out your contracts and start looking at them, or seek legal advice to help you review the contracts. So there are two main legal issues, and I'll deal with them briefly. The first is the issue of force majeure. Force majeure is essentially something that appears out of nature, like a hurricane, etc., that causes so much destruction that it's impossible to perform the contract at least temporarily. And the second legal principle is the doctrine of frustration, which means the contract as a whole is frustrated and the parties cannot complete it. So both are discharged of their obligations. Next page, please. Did you change the slide? I'm looking at a slide, but I'm trying to go by the slide, yes. So first of all, you should do, like I say, look at a contract, determine if there's a force majeure contract, or it doesn't have to be framed as a force majeure clause. It could actually have language in the contract that are, in all essentials, force majeure language. Look to see if there's one that could provide relief. Then determine if the language of the force majeure clause is generic, that is broad language, or whether or not the clauses, if the contract defines specific situations that are covered, that is providing a list. Now, many force majeure clauses will be generic, and often they'll use the act of God clause. That will be to the benefit of many, because it's unlikely that this pandemic was contemplated in many of the contracts. So based on the case law, as lawyers, I think, and my colleagues will agree with me, a pandemic will likely to be found to be an act of God. So it will be able to be considered in the force majeure category. If there's a list of scenarios in a contract, then the contracting party will have difficulty to claim that they are covered if their specific scenarios is not listed. So again, go back to the contract. Now, it's very important to remember that a force majeure clause does not in itself serve to excuse you from the performance of the contract, and many people are laboring under this misapprehension. The onus is always on the party seeking relief to establish that this thing that happened was actually contemplated by the contract, and that because it happened, it's now impossible or nearly impossible to perform the contract. So if a party is going to rely on the force majeure clause, then the party has to be very careful. It doesn't get them out of the contract totally. It just, and you will have to look at the specific contractual terms. Very importantly, always provide the appropriate notice provisions. A clause in a contract in the instance where force majeure is being invoked will often have a notice provision. So make sure you comply with that. Again, go back to the contract. To be excused from performance of a contract relying on force majeure, remember, force majeure clause will only apply for the duration of the triggering event and will not generally serve to terminate the entire contract. So again, many people are laboring under the misapprehension that force majeure will get them out of a contract completely. Well, no, that's not the case. The doctrine applies only for the duration where there's difficulty in adhering or in performing the contract. Once that is gone, then parties are expected to continue the contract. So again, the specific terms of each contract will play a very large part in determining the outcome of a force majeure assertion. Next slide, please, Vijay. Next slide, please.
It's on.
Oh, it is? Yeah. So in the absence of a force majeure clause, a party may also use the doctrine of frustration as an excuse for non-performance. Now, frustration, unlike force majeure, is not temporal. It applies when the contract becomes impossible to perform, not just difficult or costly. You have to be careful. It's saying that it's difficult or costly doesn't get you out of the contract. You can't use the frustration doctrine. So the reason for the transaction must have essentially have been destroyed by the intervening event or the pandemic. So remember, frustration is very difficult to establish. But when established, it relieves a party of their contractual obligations, both parties. This test was established in the Supreme Court of Canada in the Naylor case, and it applies when a situation has arisen, of course, when there's no provision in the contract or performance of the contract, and it becomes radically different from what the parties are undertaking. And there's strong practical and policy considerations to deny parties from getting out of their obligation. So there must be compelling reasons. So the court will look at it and use it very sparingly. A frustration argument will succeed when applied to a short-term rather than a long-term contract usually, as longer-term contracts should usually contemplate changing circumstances such as the economy, etc. So courts may be expected to look favorably to claims of frustration. And the parties looking to be excused from their contract must always act reasonably in good faith and show a willingness to compromise where appropriate. Of course, you always have to mitigate your damages. Thank you.
Yeah, so thank you, Mark, and we will look at more questions as we go along. So those of you who have questions specifically to force majeure and frustration, please send them in on Facebook. We're watching the comment section, and we will get those questions to Mark. I know we're a little tight on time, so we will move on to our next speaker, Sanj Mitra, partner at Berlis. Sanj, over to you. And Sanj's going to speak about
insolvency
options that you have to keep your business going, and in times like this. So over to you, Sanj.
Thanks very much, Vijay. So I'm going to take off from where Mark sort of stopped, because he outlined some very good options that you may face when in a contract with someone else. Generally, courts are going to require parties to enforce their contracts as written. If one party doesn't, the non-performing party is going to be responsible to pay the loss or the damages that the other party suffers because they didn't perform the contract. Let's say that after Mark's able arguments at the court, court finds that they're just not prepared to agree that that a contract has been frustrated, or that a contract has a force majeure clause which will allow the other party out. So what do you do? So I practice in the area of bankruptcy insolvency. If we could go to the next slide, Vijay. Bankruptcy insolvency, I think you went two. I think you have to go back one. Sorry. Right. So bankruptcy insolvency is governed by two primary pieces of legislation: the Bankruptcy Insolvency Act and the Companies Creditors Arrangements Act. Notwithstanding that, there's like a whole bunch of legislation that's also affected by bankruptcy insolvency. And what's the magic about these two acts? They allow you to modify or disclaim contracts. So that actually goes against the whole regime of when you have a court requiring parties to perform contracts. If one of the parties to a contract is insolvent, then they can take advantage of these two statutes, being the Bankruptcy Insolvency Act or the Companies Creditors Arrangements Act, to restructure their affairs so that they can continue on in business, but modify their obligations so that they can continue to operate. What's the policy behind that? We'd rather have, like, any business has many stakeholders: the owner, the employees, all the customers, all the suppliers. And if a company can't perform and has a problem paying its obligations, the failure of that company will affect a whole range of people. So the policy of the Bankruptcy Insolvency Act, and I'll refer to it as the BIA, and the Companies Creditors Arrangements Act, or CCAA is how I refer to it. Those two acts will allow though a business that has financial problems or is unable to meet its obligations to restructure its affairs, maybe make a settlement with its creditors, disclaim contracts that they just can't perform because they're not profitable anymore, and emerge from its restructuring as a sort of healthier entity. A couple of things I think people might want to consider. I view insolvency sort of like medicine. The earlier you can diagnose that you have an issue, the more options you have to fix it. Why do I say that? In order to get through a restructuring, you have to be able to, there are going to be certain expenses like the lawyer, like the trustee in bankruptcy. These are like your key stakeholders in any sort of insolvency process. And, you have to be able to pay them. You have to be able to fund your operations through the restructuring so that you can continue to survive. If you wait too long to take advantage of these types of statutes, you may find that your options become more limited because your funds are more limited. You may have creditors who are more aggressive and less willing to compromise and make a deal to allow you to get through a restructuring successfully. I should mention that if you're in this zone of insolvency where you might want to take advantage of these two acts, there's two types of processes that are governed mainly by the Bankruptcy and Insolvency Act. The first is the one that I'm sort of focusing on is the restructuring aspect. You can file what's called a proposal under the Bankruptcy Insolvency Act, and that proposal appoints a trustee to help you get yourself through the restructuring process. They develop a cash flow. They work with you to understand what aspects of your business may not be worth keeping and what aspects you might want to continue and emerge with as a more healthy business. The other type of proceeding under the Bankruptcy Insolvency Act is a straight out bankruptcy. And that is essentially a process where you've got a debtor that really has few options left. It doesn't have the means left to be able to do any sort of restructuring because it doesn't have any goodwill it had eroded to the point where it just doesn't have a lot of options left. And in that circumstance, what the company could consider is something along the lines of a bankruptcy. Why would that be of interest to people who are listening? Well, there are ways, even if your business goes bankrupt, if it's in a corporation, maybe you consider bankrupting the corporation and buying back the healthy assets. There are lots of options, but everything is dependent on the facts. And I can't stress that enough. I'm talking very, very generally about things that I've seen happen and I've worked on in the past. I've been doing this for about 25 years. But everything will turn on its facts upon the facts of the particular situation. So you have options, even in a bankruptcy, to try and do a form of restructuring if you do things the right way. So anyway, I wanted to highlight those two processes. How is COVID affecting the people that are probably watching this seminar? Because you're all small businesses. COVID has affected everyone. You've got small businesses that have shut down. Their landlords, for example, are not maybe getting paid because the businesses aren't operating. The landlords in turn can't pay their mortgagees. The mortgagees are sitting there, well, should I take enforcement steps? Should I work out an arrangement? What should I do? Right now, Mark was right when he said that things are in a bit of a state of flux and nothing is static, because we don't know how long this is going to last and what the effect is going to be on the economy when we emerge. So we're in a bit of a holding pattern at the moment. So we don't know where we're going to end up on the other side of this situation. My concern is there's going to be a lot of people, even though we've gotten through the COVID crisis, they may not be able to reopen. And so what do? You've got to be watching out. Maybe your customers, if you're a business and you've got customers, maybe they don't reopen, maybe they go bankrupt. And that will have an effect right up the ladder, because you won't get paid what you're owed in terms of your receivables, which in turn is going to put you in a position where you're going to have problems paying your creditors, for example, a bank or whatever other trade creditors you might have. So this legislation will affect, even if you're in a healthy situation right now, you may want to start thinking, are your customers the type of customers that are going to be able to emerge from this COVID crisis and pick right back up and continue paying you? A couple of the things I think that a lot of businesses or people are talking to, people should consider if they have at this stage, is maintain contact with both your customers and your suppliers. No one is going away quite yet. Let them know you're still there, even if you can't. You want to be able to assess in a realistic manner if you're really going to be impacted by if you've got a large number of receivables from a number of customers. You want to make sure that you get a bit of a heads up in the event they're going to have a problem paying you, even if they come out, because if they are, then you're going to have a bit of a cash flow problem when you come back. Vijay, thank you for popping the slide. I wanted to throw up the definition of what insolvency means, because not everybody will have that understanding. A lot of people talk about it. One of the things I look at it, even though this is the test from the Bankruptcy Insolvency Act, think about it this way. Are you having problems paying all your obligations generally as they come due? Are your revenues coming in greater than your obligations? Are your revenues coming in not enough to satisfy your ongoing obligations as they're coming due? If you keep falling behind, you may be in what I call the zone of insolvency. You may be an insolvent person that's entitled to take advantage of either the BIA or the CCAA. The other test, which is rarely used, is it's called a balance sheet test. In the event that the value of your assets is less than the total amounts of your obligations, then you're considered to be insolvent. So I only throw this slide in just so people understand that there is a specific definition of insolvency. in order to be able to take advantage of either the BIA or the CCAA, you need to be able to fit within that kind of a definition. So now I'll just move in. I wanted to talk in the next slide about a few of the warning signs that you as a business owner might want to consider when you're looking at your customers who have to pay you. And these are kinds of things that you're looking for when you're having these discussions to know whether, you know, there might be an impact to your receivables, which in turn is going to impact your own cash flow in the future. So one of the first determinants I see is if you've got a regular relationship with a borrower or one of your customers, and you know they owe you money, and they, you know, when you're communicating with them, it used to take, you know, they used to be back to you within the day, but now it takes them longer and longer to respond to queries. That's a really good sign that they're having bigger problems in their own business, which might impact yours later on. Some people will have actual supply agreements between their customers and themselves. Usually those supply agreements will have certain covenants. Also, if you have a credit agreement with your bank, there are going to be a bunch of covenants in that credit agreement. I'll give you a couple of examples. Most bank credit agreements will have reporting covenants, such that you have to either put in a margin report if you've got an operating line of credit, or they will have, you know, the margin report has to be submitted monthly, or they will have financial covenants, which are tested annually based on your financial reporting, your annual statements. And if you breach those, that's a breach of the credit agreement. A breach of the credit agreement usually allows your bank to demand. So that's something you want to be cognizant of when considering, you know, whether you're going to have an issue with the bank. Age of accounts receivable. So, you know, was it taking 30 days to pay your receivables? Is that what your what your credit terms are with your customer? Is it now taking longer for them to get you paid? Are they now paying you in 60 days, 90 days? If it's after 90 days, for a lot of bank credit agreements, you can't margin that debt, that receivable anymore. And I'm not going to get into margining and stuff because that's not going to be applicable to everyone, but it's an important point for you guys. So all in all, I'm not going to go through all of them, but like if you become aware of things like lawsuits against the company or shareholder disputes, that becomes an issue for that. That's a sign that you may have a debtor who's in a problem, and you may want to take some extra care when dealing with them. Thank you very much for inviting me today, and I appreciate the time.
Yeah. Sanj, sorry to cut you off a little bit there.
That's okay.
But,
that's okay.
Yeah, so thank you very much for your time. And those of you following this, there is a pattern of how we're doing this. We started with Mark that talked about force majeure and frustration. Sanj is talking about insolvency, and I think you know, I think a lot of us, I learned a lot, Sanj, you know, by the definition of insolvency as well. So it's not bankruptcy, insolvency. So we've learned something new. And now over to our next speaker. Daniel Schwartz is a partner at Thornton, Grout, Finnigan, LLP. And Daniel, we're very glad to have you on board. And Daniel's going to be talking about specifically another thing that we have as business owners is insurance. So how can insurance help us during these times? So over to you, Daniel.
Sure. Could you put up my first slide, please? The one right. Perfect. Great. Thank you. And just before I begin, I want to thank the ICCC for inviting me to this talk. I really appreciate it. And where I'd like to pick up with is something that Sanj mentioned and Mark mentioned, the uncertainty of the times. Now, certainly you have contractual remedies, which if you have to be in a lawsuit that you can rely on, or if the situation is dire, you've got insolvency-like remedies. I'm going to talk a little bit about insurance, and one of the reasons why, often the primary reason business owners buy insurance is to have protection in case the unexpected happens. You have a flood, you have a fire, you have an employee who steals from you, someone gets injured on your property, building you're building collapses. And so a lot of business owners, the first thing that comes to mind in this type of situation, particularly if they've had impact to their businesses, well, what is my insurance going to cover this? And so what I've tried to do today in a nutshell is put together some simple questions that I think business owners need to ask, and some simple steps that you can take to make sure that you figured out whether or not you have coverage, and if it's questionable, what type of steps that you can take to protect yourself. Because as the other speakers have said, we're in unusual times. We don't know how long this is going to go on. We don't know how long the impacts are going to be. But there, now is the time to arrange your affairs to protect your business, and do whatever you need to do so that when we come out of this crisis, you're going to be in the best position possible. So the first thing I want to talk about from an insurance perspective, and I should say I'm a commercial litigator. I litigate insurance disputes. I litigate construction disputes. I litigate all sorts of complex civil disputes. I don't want any of you to be in litigation. These questions here and the tips I'm giving you here are to avoid litigation and to hopefully get you some money without having to be in litigation. So one of the first questions that you think about in the insurance context, and businesses need to think about is, have I sustained losses? And so, if I'm going to be going to an insurance company and asking for money or help, I need to understand, what it is I'm looking for. So, what do I say has resulted as from the pandemic? Is it lost revenue? Is it cost to comply with social distancing? And you want to make a good assessment at the beginning. Have I sustained losses? And the losses, are they significant enough that I want to start thinking about claims on insurance or otherwise? And so once you have done that, the next obvious question that you want to ask yourself is, are those losses insurable? And what that means is there coverage for those losses under any of my insurance policy? And often this case, some of your losses may be covered and others may not be. In the case of the COVID-19 pandemic, most losses that businesses are seeing, at least particularly business with any sort of retail facing parts of their business, are business interruption. You're closing your doors, you're shutting down, you're not having customers, you're not able to operate in the manner that you're normally can. And so unfortunately, it's the case that a lot of businesses don't purchase business interruption insurance. It's a specific product. It's often an add-on. It's often can be expensive, and so it's one of the things. If you have it, it's going to be great in this type of situation, and it's something you're really going to want to try and access. If you don't have it, that doesn't mean there may not be coverage, and there are some arguments about, right now going forward, and there's already been some court cases on this about whether all risk policies, which most businesses have, this is also known as a comprehensive general liability policy, may respond to issues regarding COVID-19. So and we'll get into a moment about how do you find out whether your losses are insurable. The third important preliminary question you want to ask is, do I have accurate records of the losses? And if I don't have accurate records of my losses, if I'm going to be making any claims, you need to take steps to start documenting things. And so if your accountant is assisting you, or if you're a larger business, you may even want to consult with a private adjuster. But if you're going to be making a claim, you're going to need to be able to prove your claim. In order to prove your claim, you need to be able to show what your losses are. And so once you've dealt with those preliminary questions, what you want to do is you want to ask yourself, well, how do I determine whether I have coverage for those losses? Well, step number one, it's an obvious step, but a lot of businesses just may not have it. You got to get copies of all your policies. And I'm not talking about the renewal statements that we all see every year. Get a copy of your policy. You may not have a copy of your policy. You may have placed your insurance 20 years ago. You may not have it. Call your broker, email your broker, ask for copies of the policies. And particularly if you have a broker, now's the time where you get your broker working for you. Your broker is there. Your broker gets paid a fee for placing your insurance, they get paid a fee because they're a professional, just like a lawyer, just like an accountant, and they're there to place the coverage that's appropriate for your business. They're there to help you with claims. They're there to interpret claims. So, you know, you want to reach out to your broker and you're going to want to ask them specific coverage questions. Do I have coverage under my policies for business interruptions? If not, can it be covered under other policies? If you don't know, if you're asking me questions off the cuff, can you please ask the insurer on my behalf? And the most important thing in these types of situations, document these things. If it's on the phone, send them an email to confirm. A lot of brokers I've spoken to have already said, you don't have it, I don't think you have it, you may not have it. Get them to make the inquiries on your behalf. Now, whether or not they come back and they say you have coverage, if you're suffering a significant amount of loss, I've given advice to some clients, and it depends on a client-by-client basis. You really want to think about making a claim, even if you get denied. You know, if you have a significant amount loss, if there's an arguable case under your policy, what's the downside? And your insurer may settle with you. They may say, well, there's a big interpretation question here. We don't know. We've got some legal doctrines we can argue about. Like right now, there's a case going through the system about whether or not the COVID-19 is pollution and damage to property, which is sort of an interesting and innovative way of getting a claim into an all-risk policy. And I'm running out of time here, so I just want to give you a couple of final points. In addition to your insurance policy, if your broker didn't get you business interruption coverage, and you're the type of business where it really would have made sense to have that, and your broker never discussed that with you, there is a potential basis for recovery against your broker. And it's something you need to think about. It's pretty high bar. You need to show that you need to demonstrate that they didn't properly assess and place your coverage needs, but it is a potential source for recovery other than from your insurance yourself. So the key point is, if your losses are significant, you need to assess your insurance coverage. You should get professional independent advice on the situation. Speak to your lawyer, speak to your business advisor, speak to your broker, make sure you document everything, and consider making a claim, or at least putting your insurer on notice, because many insurance policies have notice requirements. You have to notify them of a claim quickly. And you may think, I'm going to deal with this 6 months from now when business gets back to normal. It may be better to send that letter in right now and see what they say. That way you're preserving your rights. Well, thank you very much for allowing me to join you today.
Thank you very much, Daniel. That was on topic and fantastic. I think those of you watching, I was running some scenarios in my mind here in terms of if we went in, here's all the ways we could do this, and the errors and omission of the broker as well. I think there are options here from an insurance standpoint as well that many of us would not have considered before we came in here. So thank you very much. Over to Pramod Goyal. Pramod is the President and CEO of Canada-wide Financial Corporation, and more importantly, he's the President and Board Chair of the Indo-Canadian Chamber of Commerce, and he is also my boss. So let me get out of the way, and Pramod, over to you.
Thank you, Vijay. Good afternoon, ladies and gentlemen. As my other fellow panelists have already covered some of the legal areas surrounding contractual obligations, insolvency and bankruptcy, and also Daniel covered the insurance considerations. I would briefly highlight issues relating to the pandemic's impact on cross-border trade. As we all know, Canada is still facing an unprecedented slowdown as a result of the pandemic. Schools and businesses remain shut. Borders continue to be closed, which has largely impacted the global supply chains. And if you look at from anything to everything, right from raw material to finished goods, the effectiveness of the distribution chain is impacted. We might be able to get all the essential commodities, and there is everything that is related to that, which is still functional, open. But if you look at anything that is non-essential, primarily being distributed through our retail chains or bigger supermarkets, that is not available at least. So, I mean, it has impacted the manufacturing and the distribution for those. The cross-border activity between different countries, regions have definitely been curtailed due to the restriction of movement of people and goods, which is again state-sponsored. Then we also have of late seen some restrictions coming in from several countries on some of the products, primarily on the medical equipment and some food and agriculture products related to maintaining or safeguarding certain supply levels within their own regions and countries. So globally, we see disruption. And as we go along into this shutdown, it might precipitate further. But if we look at or analyze what is Canada's position so far, so Canada is committed to supporting the global trade and investment during this health crisis. It is committing to keep its commercial borders open while eliminating, of course, the non-essential travel. It has not imposed any export controls or tariffs or non-tariff barriers on any existing trade or restrictive practices. So there, everything is as usual. In fact, if you look at Canada, along with 23 other WTO organizations, have signed joint statements to reinforce the international cooperation on trade and agriculture to help protect and promote the food security and health of the people around the world. So it is committed to that. One positive step that Canada took was also to temporarily eliminate tariffs and taxes on all goods that are imported by public health authorities, such as hospitals and testing sites, until any further notice, and relax certain regulatory requirements in terms of imports. So, which is a very positive sign. Travel limitations, though they are in place, but Canada has been vocal and ensured that it should not apply or affect any supply chains without any condition on the nature of cargo. So all movement cargo should be moving freely. The Canada Border Services Organization has also introduced policies to assist importers and exporters navigating this specific COVID-19 challenge, wherein the investigations and or any appeal processes are temporarily suspended, leading to no reports, requests, or penalties. Maybe it might have some negative impact. But so far, it is to facilitate free flow. As we move on to the next slide, if we look at the country is preparing for resumption to normalcy, or at least we can talk about partial opening up of the lockdown. What I feel is businesses must prepare a plan to navigate through the downstream effects by examining their contractual obligations, by identifying the risk, considering contingencies. And only by doing so, businesses appropriately can position themselves and build resilience in times of such far-reaching economic uncertainty. So when we talk about what the businesses can do, we can look at some of the firm level adjustments that can be done. Companies should remain vigilant and ensure that their compliance structures are robust to weather any current storm or something similar, which is unexpected. While working remotely, because most of the workforce is working remotely, it might have its own impact on mental health of the staff, and that may lead to less attention being paid to or certain oversights that otherwise would have gone into monitoring, trade activities or financial flows or compliance reporting, what we would have done in the normal course. So that might be an area that we should be focused on, should be looking at. then companies who might get affected because of anything that happens in the marketplace because of dumping or subsidization or anything as a result that is specifically related to COVID-19, and the companies are looking to get redressal or file complaints, would be required to track their financial results during this period so as to make a proper judgment. I think my colleagues earlier, Daniel specifically, was talking about that. And he did mention that you need to, keep track of things, what's going on. Of course, I mean, the companies need to focus on different products and geographies and different areas of their operation to see how it is best to mitigate the adverse impact on the operational difficulties in terms of initial execution of contracts and how it will have a result on the future obligations. From what we are seeing from our interaction with a multitude of individuals so far at the chamber, businesses are being affected by this outbreak and may have to look at multiple avenues to mitigate business impact. The avenues could be deferral of payments, delaying or avoiding performance or recovering monies owed under their contracts. And all this they can do if they do strategically and of course with the advice of an experienced counsel. What effective proactive measures can the companies undertake to help themselves better prepare to deal with the situation? They could, they should anticipate and prepare for potential counterparty defaults under existing contracts that they have. And so they should be preparing themselves for by identifying or collating key contractual documents for better accessibility, by identifying common provisions running across existing contracts that may offer resistance. They could also look at doing or identifying some necessary tests and notice requirements for invoking such provisions. And this is where a legal expert might be required because every business may not be equipped themselves in terms of looking or reviewing or taking corrective actions, even if they have coverage or they have safeguards in place. And of course, maintaining discipline around communication with other counterparties in different functional areas to avoid the risk of any inadvertent waiver of contractual rights. So all these are measures that are geared, suggestive measures, I would say, for companies or businesses to look at and be better prepared to deal with this situation. As I said earlier, I mean, we have tried to cover different aspects, though we would not be able to have covered all the related aspects that could be impacted because of this pandemic. But I think we tried to have a quick overview on few of these subject areas this afternoon, with my colleagues having taken time to speak on different areas. We would also like to have some questions that we have answered by our fellow experts from the panel. And then, of course, it'll be followed up by some of the questions that our audience who's on this webinar have sent any questions to us. So let me start with Sanj. Given the outbreak of COVID-19 and the ubiquity of the emergency orders or the regulations, various amendments that are being announced by the domestic and international government. So anything when we talk about insolvency and bankruptcy, so anything one of the key subject areas that we see is the trade credit insurance. Would that be covered under any losses that arise out of this pandemic? What do you think? Would it be applicable or would this be outside the coverage?
So I think you have to look to the actual credit insurance policy that you have. there are very strict terms, as Daniel could probably tell you, on any policy. There are a couple of providers in Canada that I've had to deal with on a number of my files. Again, it will boil down to the scope of coverage that's contained in the policy. And I think the other thing you have to, there are going to be certain timelines to put people on notice, being your insurer. I think you should be taking steps, if you have a policy of credit insurance, to make your claim. Better to make the claim and then find out you don't need to make the claim, rather than not making the claim and hoping you're going to get paid, and then finding that you're out of time for some technical reason because you didn't meet a requirement under your policy of insurance. The reason I say that, or the preamble to that is, or the context to that is, I'm really not sure when this crisis will end and where we will be when it does end. In certain instances, it may be that there are some businesses that are going to be okay. If your customer is, for example, say a Loblaws, they have been operating through the process, they've had cash flow, they can probably continue to pay their obligations. If it's someone like some other company that did have coverage, because you've got to remember, whenever you have insurance coverage for credit receivables, there are going to be certain qualifying requirements for any of your customers. One of the things you may want to consider doing right now is sitting down with the broker that sold that policy to you, reviewing it with your list of receivables to find out what kind of coverage you should have in connection with your receivables list.
Okay.
If I could just add to that, it dovetails a point that I mentioned earlier. You want to use your broker in these situations, and I completely agree with Sanj. You want to, even if they tell you it's doubtful, you don't think you probably should make the claim. You probably should make a claim. There's very, very, very little risk of not making a claim, and brokers sometimes may be reluctant in situations where it's not clear. They may say, oh, you don't want to rock the boat with your insurer. This is a situation, and I think Sanj hit the nail on the head. We don't know how long this is going to happen. If business is back to normal in a month, that'd be fantastic, and maybe the impact won't be as bad as people think. But if business isn't back to normal until next year, a lot of people are going to be wishing that they did make those claims. Even if they're all denied, then you have a potential lawsuit. You got 2 years to bring a lawsuit. And if the insurer is wrong, well, maybe you sue, maybe you get something out of it. But you need to take those steps now, those preventative steps, to put yourself in the best position possible.
Okay. Follow up on this, Daniel. Are there any timelines that should be kept in mind that should be applicable, generally speaking? I mean, maybe they might vary, but from a statute perspective, are there any timelines as to within which time frame a claim should be initiated or filed?
Very, very good question. So there's two types of timelines applicable here. You're going to have timelines in your policies in terms of how long from when you discovered a claim occurred to when you have to give your insurer notice, and those timelines can be often quite short. And then from the denial of coverage, typically it'll be a 2-year limitation period, at least in Ontario, to bring a lawsuit. Although you've got to be, particularly in complex business insurance, that timeline can be modified by contract. So you want to have a detailed look at your policy. You want to be asking your broker all of these questions. I think Sanj's suggestion of sitting down with your broker with trade credit insurance and going through all of the potential people you want to claim about is a great idea. You want to be sitting down. You want to be asking very detailed questions. You're going to want to confirm, particularly if your broker is saying, "Oh, don't worry, sorry, you didn't buy any of these things," which may be the case. You're going to want to sort of ask questions in writing, because there is the potential there for broker liability, and And at the end of the day, if you're not getting paid, you're going to want to look for a source of recovery, and you're going to want to keep as many sources of recovery available as possible.
Okay, thank you. Let me ask Mark a question. I generally hear a lot of things about this from the prospect of somebody getting sick or contracting the COVID-19. So from a legal standpoint, does the company have any sort of obligation or common law duty to publicly announce or warn its contacts or vendors or third parties if any of its employees either contracts, say, the disease or comes in, shows symptoms or comes in contact with somebody that has had it? So is there something that is required by law? Mark?
Mark, you're on mute. Can someone unmute him?
Okay, good. Generally, that crosses into the realm of personal health information. There's, as far as I'm aware, there's no statutory obligation for you to do that. I think in those instances, you may have a potential duty of care. Remember, a lot of this is very new. A lot of it will, go through this court system, and then we'll find out exactly where it's at. So there are no hard and fast answers, but as a measure of precaution, the first of all, make sure that your employees exercise proper care so that you're not in a position where you may be potentially liable for exposing your customers or clients to the disease by not ensuring that they social distance or use protective equipment. And secondly, if one of them becomes sick, then my suggestion would be to contact the public health authorities and ask them how you should deal with it. Because you're in a fine balance between protecting the person's personal information and sometimes, if we get into the issue of tracing, and also at the same time discharging your obligation. That's people to make that decision as to what extent they should go to is the public health authorities. You can ask them for their advice. So at least you can say that you took proactive measures to address the issue while trying to respect the person's privacy and private health information. Sanj and Daniel, anything to add to that?
Yeah, I would just add really quickly. I deal with a lot of sorry. People hear me? Sorry, I deal with a lot of construction businesses, and there's a general obligation under employers under the Occupational Health and Safety Act to take reasonable steps to protect their workers. And this has already come up, I've seen, in a number of construction projects where workers have been infected with the virus. You may not have, and Mark quite rightly pointed out, there are privacy obligations about not necessarily naming who has it. But if you're an employer and you have an employee who's infected or who is suspected to be infected, as an employer, you have obligations to all of your other employees to ensure and take reasonable care to ensure that your workplace is safe. So in the context of COVID-19, what I've seen happen, at least in businesses that have had to continue to operate, is you shut down your site, you clean your site, you let everybody know who was on the site, including your employees, including your sub-trades. And the same could be said for lots of other businesses that have continued to operate in a reduced capacity. Take a restaurant. Lots of restaurants are working very hard to try and survive this by doing takeout delivery model. Well, if you have someone who's sick, you're going to want to close down. You're going to want to take those steps to prevent injury, because if you don't and someone gets sick, well, we haven't seen this yet, but I think we are going to see personal injury type claims arising out of the pandemic, whereas someone will sue a business, someone will sue an employer and say, you didn't take reasonable steps to protect me as an employee, as a customer, and I got the virus and I got sick, I died, you know, that sort of thing. We're going to see that there's already been a class action commenced against nursing homes for failing to protect individuals. So as business owners, if you have any employees or any customers who come in who've been infected, you want to get advice from public health and other people about best standards to make sure that anyone who could have come into contact with this knows. You don't necessarily have to let them know who had it, but letting them know that it's happened. And people will see this in the media. You know, I saw my favorite supermarket recently sent out a notice that they're closing down for 2 days. They didn't say why, but it's obvious why. Someone got it and they're cleaning the entire place. So it is an obligation that you have as an employer, and I exercise caution.
Thank you, Daniel. I think just to add or to clarify what you said, of course, there could be potential liability suits that might come in, and as we would see, but would it be important for somebody who is initiating those claims to have actually contracted the disease as a result of any failure or ignorance or, oversight, or having suffered some injury as a result of that, or suffered some loss? Or could it be just a claim in general that it might have cost?
Well, it's a really good question. So you're talking about a legal concept called causation. In order to be successful for a claim, a lawsuit for what's called a tort, which is a type of law when you're claiming that someone was negligent or other things, you need to be able to prove damage. So you were sick, you were injured, you died, or you're a family member, you lost, you know, that sort of thing. So you need to have damages. There needs to be a breach of there needs to be a duty of care. And what that means is whoever you're suing has to have an legal obligation to you. So like I said, under the Occupational Health and Safety Act, an employer has obligations to employees and others who come to their site. As you know, you as a property owner, you have obligations to people who come onto your property. So there's lots of different, a doctor has obligations to their patients. So you have to have a legal duty, and the person who has the duty has a standard of care. And I don't want to go into all the legalities of it, but effectively, what's the best standard? So in a retail store, if you didn't tell anyone that 6 of your employees got COVID, you didn't shut down, you didn't wash, and a whole bunch of customers get COVID, and 3 or 4 of them die, well, I think you're going to have a good argument there that you breached the standard of care. And then finally, to your point, you need to be able to establish that the loss that you sustained was caused by the breach of the standard of care. And it may be difficult in this pandemic to establish that. And there are there's usually the test called but for, which is like, but for me going into the grocery store, I wouldn't have contracted COVID. There are alternative legal theories called material contribution, loss of chance doctrine, and I fully expect to see people who have sustained serious personal injury, physical injury, have become sick, didn't recover well, died as a result of this, arguing all of those things. So the short answer to your question is yes, there's a possibility of liability. So the best thing for businesses to do is be very cautious about this.
Thank you, Daniel. And I had not many questions, but I guess we're running already over time.
Yes. Pramodji,
on to Vijay, if you have any questions from the audience.
Yes, I think it's been such an interesting discussion that we've actually gone past our time. But we've got a couple of questions, so we'll be fair to the audience. We will take a couple of them. One question that I have, this is to you, Mark. This is a person from Quebec. Says force majeure. Is it in Quebec? There's a different meaning of force majeure, and is it Ontario? Is it a provincial concept, or is this something that goes across Canada? Is there a provincial aspect to this as well?
Well, force majeure is a concept that emerged is in common law. But actually, I believe it emerged from the civil law. So you've got a civil code in Quebec. There will be applications of force majeure in Quebec, but it may take different manifestations. I don't practice in Quebec. I'm an Ontario lawyer, so I don't know the specifics, but I would. But they will have to look at their contract and whether or not there are any specific provincial legislation that deals with it.
Okay. Thanks, Mark. And next question is to you, Daniel. And this will be our last question. If anybody has any more questions, please send it to us. We might be able to take one more, but this one is otherwise the last question. So, Daniel, we're thinking this is going to be a longer term thing. Now, if you're not affected as yet, could you go and buy insurance right now? Potentially, you're not affected, but you could be affected 3 months from now, and I'm going to go buy insurance. Is it possible for me to buy pandemic insurance right now today?
Well, I would love to say anything is possible, but I can tell you every insurer right now is going to be excluding the current situation. They'll allow you, I'm sure, to place pandemic policies for the next pandemic and not this one. So unfortunately, and even business interruption, this is going to be an exclusion no matter where you go. Maybe someone can find it, but I would be shocked if any insurer was prepared.
My answer was going to be, you could probably get it from Lloyd's, but you couldn't afford the premium.
That's even that. How do you even price the risk?
I was being facetious.
Yeah.
If I may, Vijay, one of the things that, and it's probably the subject of another webinar, but for our listeners or people who have tuned in, is the issue because many small businesses have employees. So be careful about employee contracts and make sure that at minimum, look at the contracts carefully, and at minimum, you respect legislative regimes such as the Employment Standards Act.
Mm-hmm. So thank you very much. On that note, we will come to our end. We're actually a little over time, but thank you very much to our panelists, Mark, Daniel, and Sanj, and Pramod for those tough questions. And most importantly, thank you very much to our audience for attending. And this is going to be on Facebook for posterity. So I think this is a really important one to let your friends know as well. They can come in and view this at any point of time. And again, those of you who want to know more information about today's webinar, want to become a member of the ICCC, or want to know something about a small business assist program, please write to ICCC@iccconline.org. And next week, same time, we have a session on COVID-19 and real estate. We're going to have, again, a fantastic panel. We want to talk about different things. A lot of us have a lot of our money, a lot of our net worth in real estate. So this is going to be really important based for all of us. So and on that note, I'd like to extend it to Pramod for some last comments. Over to you, Pramod.
Thank you, Vijay. I would like to extend our warm wishes and thank you to all our panelists who took the time and to come and share their thoughts with our members and audiences. Thank you very much for your kind support. Look forward to interacting with you later on. Thank you.
Thank you for inviting us.
Good evening, everybody. Take care.
Good night.
Bye.